The top 5 Code of Ethics articles charged against Arizona realtors were Articles 1, 2, 3, 12, and 15, not necessarily in that order. Interestingly, most of these articles are consistently in the top 5 articles charged year after year. For that reason, it is imperative to gain a better understanding of what type of wrongdoing is being alleged so that you can avoid a potential violation. Article 1. Treat all parties honestly. Protect and promote clients' interest. Generally, Article 1 allegations are filed when a person feels as though they were not treated honestly, or their interests were not promoted. Examples are: 1. The buyer believes their realtor, R, did not protect their interests when the realtor, R, would not submit an offer in the amount the client wished to submit. 2. The buyer believes they were not treated honestly, and the listing realtor, R, put their interests before the buyer when the buyer submitted a full price offer, but the seller accepted a lesser offer from someone else. And 3. The seller believes the listing realtor, R, did not protect and promote the seller's best interests when the realtor, R, did not listen to the seller's specific showing instructions or directions for viewing the property. Article 2. Avoid exaggeration, misrepresentation, or concealment of pertinent facts. Disclose, 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 and don't misrepresent or conceal information related to the property or transaction. This article is not limited to the disclosure of property issues. Remember, this article also applies to a person's ability to finance a property, the status of financing, or even the seller's ability to move out of the property. Article 3. Cooperate with other brokers. Under this article, we have seen an uptick in realtors accessing properties when they do not have permission. For instance, a seller lists their property with specific instructions that all realtors should call for an appointment prior to viewing the property. However, the realtor R disregards the instructions or does not pay attention to the notes in the MLS and thereafter accesses the lockbox and enters the property without permission. Article 12. Honest and truthful advertising. Realtors are for the most part self-policing when it comes to this article. Put another way, realtors usually file Article 12 complaints against other realtors because 1. The realtor did not identify themselves as a licensee, or 2. The realtor is touting misleading statistics about their sales in their advertising. The general public's complaints are usually that the property was not what was advertised. In other words, the MLS stated something different from what the public believed they were purchasing, e.g., wood flooring versus laminate, or Brand A appliances versus Brand Z appliances. The public also files complaints alleging a violation of Article 12 when the public cannot distinguish between a team leader, member, and broker. Article 15. Knowingly or recklessly making false or misleading statements. Social media and lack of direct communication, i.e., talking to each other, have led to increased alleged violations of this article. Issues range from comments realtors, make on Facebook or other social media platforms to emails someone accidentally replied to all, or a forwarded email thread which contains a disparaging remark. For example, Realtor B has your property listed too high. I could do a better job. Or, I can sell your home quicker than Realtor C because Realtor C doesn't do XYZ. While Realtors cannot always stave off the filing of an ethics complaint, they can protect themselves by ensuring they communicate with all parties and documenting their file if or when an issue arises. When courts look at NAR's Code of Ethics. NAR's Code of Ethics clearly makes realtors respected leaders in the real estate industry in the eyes of courts. Scrolling through the NAR archives, I discovered a previously published article related to the Code of Ethics and court interpretations. This article offers insight into how the courts view the Realtor Code of Ethics when deciding court cases and the rationale behind those decisions. I knew it was a great find to share with our members. Jan Stewart, AAR Risk Management Specialist, NAR's Code of Ethics, may be to realtors are what the law is to ordinary citizens. There are rules, means of enforcement, hearings for the accused, and punishment for the guilty. But can it hold up in real courts of law? Absolutely. In case after case, courts afford the realtor our code of ethics just as much respect as case law, statutes, and license law in determining what standard of care a real estate professional owes the public. And courts often hold all licensees to the high standards of the code, whether or not they're members of a realtor association. What's more, courts consistently support the realtor organization's enforcement of its code of ethics. A good illustration of how courts look to the code of ethics for guidance is found in Norman Thefers Krug Real Estate versus Prasker, 1994. In that case, a listing broker named Prasker failed to disclose to a potential buyer that Krug had an unrecorded security interest in the property. Prasker also failed to discuss the pending sale of the property with Krug so that he could record his security interest. When Krug learned of the sale, he sued Prasker for negligence. The California Superior Court ordered Prasker to pay Krug $27,000. When Prasker appealed, the Court of Appeals began its analysis by noting that the imposition of a duty on a realtor to disclose a known unrecorded lien interest is supported by standards already existing in the industry. The Code of Ethics of National Association of Realtors, provides that a realtor has an obligation to treat fairly all persons to the transaction, Article 1, and to assure that all financial obligations and commitments must be reduced to writing, Article 9. The court also took judicial notice of the Code of Ethics as bearing on the standard of care for professionals in the industry. It also quoted from the preamble to the Code of Ethics. The term realtor has come to connote competency, fairness, and high integrity resulting from adherence to a lofty ideal of moral conduct in business relations. No inducement of profit and no instruction from clients ever can justify departure from this ideal. The court then affirmed that Prasker had breached his duty to both the buyer and Krug and upheld the lower court's ruling. The code's broad reach, a case that demonstrates how courts don't always distinguish between realtors and non-member defendants in relying on the code as the standard for the real estate industry, is Menzel vs. Morse, 1985. In that case, the buyers, Mr. and Mrs. Menzel, purchased a new construction home on the basis of various representations and assurances of Morse, a salesperson with Dave Jones Realty, the listing broker for the property. The Menzels mistakenly believed Morse was representing them and their best interest. When it turned out that the property had extensive defects, the Menzels sued Morse and Dave Jones Realty for breaching their fiduciary and contractual duties and for negligence. The trial court dismissed the Menzels' claims, reasoning that the defendants had no duty toward them. On appeal, however, the Iowa Supreme Court cited numerous cases that had found that the realtors code constitutes the established standards of conduct in the industry. In fact, the court noted that even though there was no indication that Morse was a member of a Realtor board, he had admitted at trial that the Realtors code was widely recognized and uniformly accepted by real estate salespersons and those in the real estate world in general. Morse had also admitted that he was aware of the relevant provisions of the code, including Article 2, which states that realtors have an affirmative obligation to discover adverse factors that a reasonably competent and diligent investigation would disclose. The court then reversed the trial court's decision and remanded the case because the trial court had erred by rejecting the standards of skill, knowledge, and conduct conceded by defendants to be applicable. On a similar issue is the case Baker v. Late, 1962, in which a homebuyer brought an action for fraud, rescission of the contract, and unjust enrichment against the seller and the seller's broker, who was not a member of a Realtor association. In reversing the decision of the Arizona Superior Court in favor of the seller and his broker, the Arizona Supreme Court stated, "It is immaterial as to whether the broker is a member of the National Association if it is established that this association code of ethics is applicable to those in the real estate profession in this state." The court further noted that NAR's Code of Ethics is regarded as the standard of conduct by real estate men throughout the United States and shall be regarded as such in the state of Arizona. Courts-backed code enforcement courts also recognize the societal value of our Code of Ethics through their consistent support of our enforcement of the code against realtors, who don't live up to its high standards. Courts typically say they won't interfere with our enforcement of the code so long as we follow our own disciplinary rules, and so long as those rules are consistent with fundamental due process, whether it be fines, suspensions, or other disciplinary actions. One of the landmark cases on this point was Kendler v. Rutledge, 1979, which stated that judicial review is limited to ascertaining whether the association's power was exercised in conformity with the association's internal law and the members' fundamental fair hearing rights. In a similar case, Stewart v. Colorado Association of Realtors, the District Court of Colorado said that the court shouldn't interfere with the internal operations and affairs of voluntary associations. The court noted that Colorado recognizes that membership in a voluntary association is contractual and that members agree to submit to the rules and regulations of the organization and assume the obligations of membership. The only exception to this rule would be when an enforcement procedure was clearly arbitrary and an unreasonable invasion of a member's rights, the court stated. Not licensed for law. In an Iowa court case, 2 real estate agents were found liable for $536,250 for failing to advise sellers to seek legal advice. In Crutchley v. First Trust and Savings Bank, 1990, the installment contract for the sale of a property contained a non-recourse clause. The sellers didn't fully understand the clause, which limited their rights upon default to whatever payments had been made by the buyers prior to the default and regaining the property itself. Subsequently, the value of the real estate in that area sharply declined, and upon default by the buyers, the sellers were forced into bankruptcy. The sellers had to sell the property at a significant loss and then sought to recover money damages from the agents. The sellers contended that the agents failed to observe Article 13 of NAR's Code of Ethics by not recommending that they seek legal counsel regarding the non-recourse clause. The trial court held that the agents were at fault under breach of contract and negligence claims. In affirming the lower court's decision, the Iowa Supreme Court relied on previous case law establishing that the violation of NAR's Code of Ethics is sufficient to determine negligence. NAR's Code of Ethics clearly makes realtors respected leaders in the real estate industry in the eyes of courts. And as the Professional Standards Committee comes closer to implementing new procedures for code education and enforcement, it's important to stress that NAR has consistent and strong court backing for the code. Realtors need to understand the importance of the Code of Ethics and take it as seriously as the courts do. After all, we set the standards for the industry,